And I think another way to look at that is also when you think about NDAs, IP, think about, let's say someone did violate this agreement. Are you going to go sue them? Are you going to go through the legal trouble of resolving whatever you want to, whatever the situation is? Because that's, I don't even know how much a lawsuit costs. Could be anywhere from what, 5K to 100. I have no context. And so are you even going to go through that process? Because if you're not, then again, what are you protecting? And so understanding those levers and being okay with the 2-page MSA, knowing that if you do need to go to court, maybe the 2-page is not the best way as an 80-page would. But the mental piece of, okay, let me start with this, and then as I grow, I add stuff, modify stuff, addendums and everything, right?
Yes, exactly. And that's one of the big things that is I'm a corporate attorney, not a litigator.
Yeah.
And so all of our job is, as a corporate attorney, is deterring those kind of actions. But you're right. Once someone says, well, I'm going to do it anyway, come after me, it's hard in our legal system, honestly. It's very hard to actually enforce these. It's very hard to go to court and get this done. And so, a lot of our business goes more on reputation and
Makes sense.
just being able to say that you don't break contracts than actually going after the person. So yeah, exactly. You don't need to do all this because especially if you're doing a contract for, $25,000 and less, no one's going to even look at you if they just steal that from you, but that might ruin that person's career.
Yeah.
So that's what you worry about.
Yeah, 100%. And pivoting a little bit, right? Let's say I'm an early startup. I have an idea. What's your recommendation on how do I go about doing the initial things? And if you have a recommendation of like, do a formation, IP, whatever, like, what does that look like for me as an early stage founder? I'm a solo founder trying to build a tech company, right?
Yeah.
What are the initial things from a legal perspective that you would recommend this person look at?
So the biggest thing you do is you break yourself from the company. Even though it's basically you, the founder, you want these liabilities cut, right? Because if the company goes bankrupt, all this stuff like that. So that's why we do formations of entities. But most people do that and then they don't do the paperwork to actually make it exist, which is something like assigning your intellectual property into the company. That is something that is simple, but if you don't do it, then that company is technically not owning whatever it's doing, so it doesn't become a real corporation in that sense. Making sure you do the board, making sure you assign the actual shares to you. So many people do the certificate of formation that they're told on LegalZoom to send in and don't do the document where then they go and buy the shares they created. So now it's a company that no one owns as shares. And I've talked to people and they go, well, I started it, they're mine. I go, where? Where does it say that? And once again, all this stuff doesn't matter until it matters. And so it's either you're getting investors and third parties, or you start trying to rack up losses for tax benefits.
Yeah.
If you build a fake company that doesn't have any of the correct stuff, and then you try to tell the IRS that, hey, all my losses are racked onto this thing, they're going to say no very, very quickly. So those are kind of the real concerns, is that you want to make sure the company, as much as it feels silly, is being run by the books. And it's really not that much overhead. The formation really gets you started for that, but I think that's the biggest thing.